So yes, yesterday we were discussing about the last one. I think was corporations. So what happens in case of corporation? When can corporations be sued? Okay, I think that's what we were discussing. So yeah, corporations can also be sued. Okay, uh, but for almost all the torts except there was this idea, okay, that corporations cannot be sued for certain torts that require mental element, okay, in the sense, for example, if the requirement is of that of malice, okay, for example, in case of malicious malicious prosecution, or case of deceit, okay. So as we discussed earlier, that corporations are not humans. So earlier, there was this mistaken belief that, okay, they are not capable of having certain mental element, but which is not the case. The reality is that corporation is always managed by some or other humans. Okay, so ultimately you have to attribute some mental element to the corporation, so that exception is no longer applicable. So yes, it can be sued for malicious prosecution, deceit, etc., etc. Now the corporation can be sued for which acts. Okay, so corporation does not act in itself. Okay, it acts through its employees. Okay, so which acts of the employee will make the corporation liable. Okay, now when a corporation is created, okay, there's certain purpose for which the corporation is incorporated. Okay, it is only for acts with respect to what it has been incorporated for. In within that, okay, any act which is done within the purpose of the incorporation will, any act within that purpose of incorporation will make the corporation liable. Okay, now there might be an employee, imagine, okay, there is an employee of the corporation, okay, while he is going back to home from his work, okay, he by negligent or rash driving causes some kind of harm to someone. Now that's purely within his own personal capacity, isn't it? Now, if he were doing some job, okay, which is, within the purpose of incorporation of the corporation, okay, and in that course of action, he was being negligent and ended up harming someone, then the corporation can be made liable, okay. So I hope you understood the distinction, okay. So yeah, mm, and in not everything, as I said, the act which has been done, okay, has to be within the scope of the authority of the agent employed by it, okay. So yeah, so you have been employed to do something, and then you just left your business, you went somewhere else, okay, did something, and in that personal capacity you do something that leads to certain civil action. For that, it will not be the corporation that will be made liable, it will be the individual who has done it, okay. But this is with certain exceptions that we will discuss later on when we take up specific cases, okay. So for now, just keep in mind that, yeah, it has to be an act which is within the purpose of incorporation of the corporation, okay, and an act which is done within the scope of authority of the agent employed, okay. So you have been employed for a certain purpose, you leave your job, you go somewhere else, do something, then you won't be. But if you are acting as an agent of the corporation, and while doing that, okay, while being an agent or employee of the corporation, you do something, then of course the corporation can definitely be made liable, okay. So that these are the situations when you can sue the corporation. So I hope this is clear. Is this clear? We will discuss this in greater detail when we take up specific torts, okay. So for now, this is essentially the idea. The next important one is highway authority, okay. So earlier, see, in India it's quite simple, okay. So highway authorities, okay, whichever NHAI that you have, okay, National Highway Authority of India. So earlier the idea was that such authorities under the English law, okay, under the English law, the idea was that such authorities cannot be made liable, okay. But later on certain changes were made, okay. Now in England, highway authorities are in fact made liable for example, negligent maintenance of work, okay, of the road, okay. They For example, there's a highway, okay, and there's a, something has been dug, okay, some digging has been done in the middle of the road for repair, but they fail to install any warning sign, okay, and then while driving your car or your motorbike, you fall in that, trench which has been dug, okay, and in such case, can the highway authority be made liable? As the law stands today, yes, the highway authority can in fact be made liable. So the rule applies even in India, okay. So you have this case, but I'll just type it here, okay. And I will also send you guys a link you can refer to. Okay, so in this specific case, okay, what I just told you has been, confirmed, okay. So it has been, in this particular case, the Highway Department of the state of Tamil Nadu was held liable by the Supreme Court for negligence when public transport vehicle plunged into a river owing to the collapse of a culvert. Okay, so you guys can look at this case, okay, can go into the details, okay. Essentially what happened is that highway authorities also have the duty of, maintaining the road, okay. If they fail to do so, for example, some bridge, some culvert has been built, okay, and it wasn't maintained properly, or it was not built properly, okay, leading to some accident, causing you certain, harm. In such case, we have authorities, for example, of the, this case that I have shared, you can initiate a suit as against the authority. So that's the rule with respect to, highway authorities, okay. Any questions so far? Is it clear? Any difficulties in understanding? So you can sue the highway authority. So, and then the next one is unincorporated, associations. Now, what are unincorporated associations? So, we just discussed a little while ago about corporations. Now, we discussed what corporations are. Of course, not in great detail. We will discuss that later on. But the difference here is that once a corporation is incorporated, the corporation has a body corporate to which we, attribute some intention, okay? And it has a separate legal personality, okay, separate from the individuals who create it, okay, who constitute it, okay. So once the corporation has been incorporated, it has a separate legal personality, also known as SLP, okay, capable of suing or being sued, of owning property, etc., etc., okay, perpetual succession, whatever. But not all associations, okay, are corporations, okay. There could be certain associations, okay, of humans which are not like corporations. So they do not have separate legal personality. They are just associations of individuals, okay. So what happens in those cases, okay? How can they be sued, okay? That's a question that we quite often deal with, okay. So in this regard, you have to look at the procedural laws in India and certain other laws as specific laws as they exist, okay. So for example, in case of I'll just type it here. So Order 1, Rule 8, CPC, okay. Order 1, Rule 8, okay. It says where there are numerous persons, so essentially more than one person, having the same interest, okay, in one suit, okay. One or more of such persons may, with the permission of the court, sue or be sued or may defend in such suit on behalf of or for the benefit of all persons so interested, okay. So if their interest is the same, okay, so in such case they can join together and sue, and they can also be joined together and be sued, okay. So joint tort feasor being a case, okay. So if multiple people committed a tort together. So yeah, this provision says that even though those people will be individual, and you can also institute a suit separately, but they can also be joined together to institute a suit. Okay, so these separate individuals do not constitute one whole. Okay, they are just separate. But even in those cases, such or incorporated, bunch of people can also either sue or be sued under this particular provision. Okay, the same goes, for example, for a firm. Okay, partnership firm. Okay, now you know that the difference between a partnership firm and a corporation is that while a corporation has separate legal personality, a partnership firm does not. Okay, just those partners together. Okay, so what happens in that case? So you have Order 30. Okay, CPC. It refers to suits by or against a firm. Okay, so that's what where there are difficulties, you can basically refer to these specific procedural laws to institute a suit. So I hope this is also clear to you all. Okay, so if you refer to Order 30 of Civil Procedure Code, you will see that the Rule 1 there. Okay, Order 30 Rule 1 says suing of partners in the name of firm. Okay, now as you know, the firm does not have separate legal existence. Okay, independent of the partners, unlike a corporation. But even in such cases, suing the partner in its name is allowed. Okay, so it says any two or more persons claiming or being liable as partners and carrying on business in India may sue or be sued in the name of the firm, okay, if any, of which such persons were partners at the time of the accruing of the cause of action. And any party to a suit may in such case apply to the court for a statement of the names and address. Okay, whatever. So we don't need to go into the details, okay, so that you will study later on in CPC. But you know that Order 30 Rule 1 allows partners who are otherwise not considered as being one whole, okay, separate, okay, from their individuals, for this purpose of being sued and to sue may be treated as, in this case, restricted to being sued and sue, okay, as a one separate entity, and not otherwise though. Okay, the liability would be separate here. So yes, I hope it is clear. Is it clear? The case of, are you guys clear with the distinction between corporation and unincorporated association, like for example firm?
Sir, can you please give us the definition of incorporated association, unincorporated association?
Examples?
No sir, definitions.
Okay, so see, I gave you guys the definition already. Okay, so let's understand what incorporation is. Okay, so corporation means you create a body that does not exist in reality. Okay, you are a human, you have a human body, your legal personality, your natural personality is recognized. Okay, now in certain case, okay, so when by virtue of a statute or under the Companies Act of 2013, okay, under this act, a company can be created. Okay, now you know that company has many shareholders. Okay, now once the company is created and it is incorporated, the shareholders are separate from shareholders independently. Okay, are separate from the company which is created. Okay, do you understand the difference? Okay, so the company's liability will be the company's liability, and the shareholder's liability will be limited by the share that he holds. Okay, it will not be extended to his personal property. Okay, so once the incorporation happens, okay, the corporate body which is created has a separate legal existence. Okay, now you come across many such other things that seem to be like a corporation, but they are not. Okay, so you hear about partnership firm. Okay, and a few people come together, they create a firm, they do business. Okay, now the firm seems to be like a corporation, but in law they are not. Okay, because the firm does not have a separate existence independent of the partners. Okay, the firm and the partners, same thing. Okay, and the partners are all liable. Okay, So here's the difference, okay? So because the firm does not have a separate legal existence, okay, and these are essentially a bunch of people, okay, bunch of partners, okay. Now, how to sue them? They're all individuals. How do you sue them? So law provides you, okay. So under these, provisions that I have just mentioned, for example, in case of, a firm, your CPC Order 30 Rule 1 allows you to sue them, the partners, in the name of the firm, okay, even though the firm does not have a separate legal personality, okay, but even though it does not have separate legal personality, you can sue all of them in the name of the firm, okay. Is it clear now?
So,
Yes.
if I got it right,
Yes.
you said partners consider while suing partners can be considered as one entity, but the liability can be different, right?
Yeah. So see, it's a there is something called joint liability. Okay. So
Yes,
we
sir.
have not gone into all those. Okay. So the thing is that in such case, if there is a so do you turn your this echoing going on, okay. So in case of joint liability, what happens that so for example, a partnership firm, okay, you lent money to them, okay,
Yeah.
and so they are jointly liable. So suppose they are jointly liable to you, okay. So you have lent them, suppose, okay, there are 5 partners, you have given them 100 rupees, okay. So one partner will not say that, okay, I am liable only up to the extent of 20 rupees. So there are 5 of us, in total it will be 100. No, each one of them will be liable for 100 rupees. Now the thing is that you can either sue all of them for 2020, or you can sue one of them for rupees 100, okay. But if you sue one of them for rupee 100, then what will they say? Okay, no, I will not give it to you. It's not like that. Yeah, after that, one of those partners can go against the others, seeking contribution, but that's different. So that's the concept. So let me not go into all that, okay. For now, let us restrict ourselves to this question here, okay. That does the partnership form here, okay, does the partnership form here, does it have a separate legal existence or not? Under the law, it does not, okay. So the firm and the partners are the same thing. Whereas in case of a corporation, the shareholders have their own independent existence, and the corporation has its own existence. The shareholders' liability only exists to the amount of share that it holds. Okay, so if the corporation were to go broke, okay, declared insolvent, to realize others' debts, okay, because you hold a share, your property will also not be made liable. Okay, only the share that you hold. Okay. Now, the thing is this, I hope you guys understood the distinction, the basic distinction. We will discuss about this in greater detail, maybe later, okay, in corporate law, you will be taught about all this. Usually we discuss about this preliminary issues in jurisprudence too, but you do not have that. So anyway, so in those situations as well, even when in these partners, okay, do not have separate legal, existence, but they can nonetheless be sued in the name of the firm, okay. So this is what this particular provision of law allows, okay. The same goes for societies, okay. Societies, if it corporate societies that you might create, okay. So such societies which are created, okay, under the Societies Registration Act of 1860, okay, section 6 of the said act allows you to sue the said society. So I'll just type it here. Okay, do you guys see it?
Yes, sir.
So it says, okay, every society registered under this act may sue or be sued in the name of the president, chairman, principal secretary, trustees, as shall be determined by the rules and regulations of the society, in default of such determination, in the name of such person as shall be appointed by the governing body, etc., etc. So without going into details, it's just this, that even in case of societies created under the Societies Registration Act 1860, section 6 of the said act allows you to sue the said society, okay. Now another situation arises, okay. It's trade unions. Trade unions do not really create much problem for us in India, because trade unions in common law countries, sometimes they are treated as corporate body, sometimes they are not treated as corporate body. But even if they are not treated as a corporation, then nonetheless treated like a corporation. But in India, we do not have such confusion. Okay, so we have Trade Unions Act 1926. Okay, and Section 13. I will just type it here so that you guys can see. So as you see, Section 13, the Trade Unions Act 1926, it says incorporation of registered trade unions. Okay, so once you incorporate, it becomes a body corporate. Okay, so it says every registered trade union shall be a body corporate by the name under which it is registered. Okay, and shall have perpetual succession, common seal with the power to acquire and hold both movable and immovable property, and to contract, and shall by the said name sue and be sued. Okay, so the last bit is important for us. So if it is a trade union, it can be sued and sue in its name. Okay, but not every act of a corporation, a trade union will amount to will qualify for a civil suit. Okay, because trade unions also exist for a certain purpose. Okay, and they have what we know as this act of collective bargaining. Okay, so collective bargaining is very important for trade unions. So not every activity of the trade union can be considered as a matter of initiating civil suit. Okay, so Section 18 of the said act, gives certain immunities to the trade unions. So in certain matters, you cannot institute a civil suit as against the trade union. So that's Section 18 of the said act. Okay. Now the details don't really matter much, but if you want to know, you can just Google it, you will find it. So it says, no suit or other legal proceeding shall be maintainable in any civil court against any registered trade union or any office bearer or member thereof in respect of any act done in contemplation or furtherance of trade dispute to which a member of the trade union is a party on the ground only that such act induces some person to break a contract of employment, or that it is in the nature it is in the interference with the trade business employment of some other person, or with the right of some other person to dispose of his capital or of his labor as he will. So as you know, so in such case you clearly see that interference with trade business will clearly amount to a tort. Okay, but trade unions have that immunity. The reason is quite simple, that trade unions are given the power of collective bargaining. But you see, in today's time, there is increasing erosion of this power that the trade unions possess. But nonetheless, you guys should know that this is the immunity that trade unions have. So are you guys with me so far? I don't see most of you.
Sir.
Turn your videos on again. Most of you are gone. It's 4 o'clock. I need some motivation, so be there. So yeah, to trade unions. I hope this is clear. Okay. Then next what? Next is let's see. Okay, next is insolvent. Okay, insolvent. You know who is insolvent? A person who has gone broke. Okay. So in such case, what happens? A person who has been declared as insolvent under the law. Okay. When someone is insolvent, that person has no property. Okay, whatever property that person had is now in the hand of some receiver. Okay, or administrator. Okay, so he does not have any property. So what happens? So what kind of So here, see, if any tort is to be committed, it is to be committed as against the property which is in the hand of the receiver, okay, who is essentially administering the property of the insolvent, okay. But even though that person does not have property, okay, that person has a personality, doesn't he? Okay, so wrongs of that sort will definitely be recognized, okay. So yeah, all other sorts of defamation, okay, malicious prosecution, etc., etc., would still be possible, okay? But with respect to the property, it does not belong in him. So yeah, no case of tort with respect to the property, but there can definitely be tort with respect to the personality of the insolvent. I hope this is clear, very simple. But one more thing. What I'm talking about is only after a person has been declared to be insolvent, okay? Now, while the person, now if the matter is before the person is insolvent, okay, before the person has been declared as insolvent, okay, or while the thing is going on, or while the process is going on, then obviously if that person is sued and some liability arises, then obviously it will be realized as against the property that still belongs in that person. But once the person has been declared as insolvent, yeah, that person has no property now, okay? So no tort with respect to that, okay? No liability with respect to that property either. But can you wrong that person's property? The property no longer belongs in him, okay? Can you wrong that person? Obviously that person can definitely be wronged, okay? So yes, that's the case with respect to insolvent. So this is clear? Is it clear?
Sir,
Yes, sir.
that person can still commit torts against persons, right? That insolvent person can still commit assault, trespass,
exactly.
bad defamation.
That person can still commit tort, okay? But will the property which is now in the hands of the receiver be liable? Now, once the person has been declared, as insolvent, no. But while the person is going through that process of insolvency, or before that, if that person has committed tort, then obviously there will be certain property liability. Yeah, the liability will definitely apply as against his property. But once that person has been declared as insolvent, well, no. Is that clear, Shivang? Okay. Any other question? Okay, then the next one. I'm sorry, I'm moving a little, fast today because you guys do not have too many classes because we started quite late, so we have to complete this. Okay. Now another very interesting thing that we have to discuss at this stage is that what about the state? Okay, the state. Okay, and its officers. Okay. What about them? Do they have liability? Okay. Now there is something called sovereign immunity that I don't know if you guys have heard of. Okay, but it is nonetheless an interesting conception to know of. Okay. Now there is a philosopher that you will study later on in jurisprudence. Okay, by the name John Austin. We attribute this modern idea of sovereignty to him. Okay, so sovereign is considered to be the superior. Sovereign is the lawgiver, and no law can be given to the sovereign. Okay, that was the traditional idea, kind of feudalistic, remnant of a distant past. Okay, so the earlier idea was that sovereign can do no wrong, or in if you understand this, there is this saying that goes, king can do no wrong. Okay. So essentially, king is the sovereign, the lawgiver. What law can bind the sovereign? Okay, so whatever the sovereign does is fine. Okay, so there can be no liability that can be imposed on the sovereign. Okay, that was the traditional understanding as it existed in England. Okay, but with the passage of time, okay, the crown as it exists in England is also subject to many different laws. Okay, so this immunity no longer exists even in England. So in England they enacted a law known as the Crown Proceedings Act of 1947. Okay, I'll type it. The Crown Proceedings Act of 1947. Okay, so under this, okay, certain immunities. Okay, so for example, the sovereign head, does enjoy certain immunities. So for example, the president in India or the governors enjoy certain immunities. Okay, while holding their office. Okay, their office holds certain immunities. But state does so many other things. Okay, state does so many other things. Okay, as of now, the state we understand state as service state. Okay, the state is no longer just a sovereign king sitting in his chair. Okay, and ruling over you. It's not like that. The state provides you so many services. There are trains, buses, and whatnot. So many things being done. Okay. Now, if a tort arises from all those activities, can the state say that no, we are not liable? No, that's not the case. Now the crown, even in England, the crown can be made liable for tortuous acts. Okay, that is the established practice as it exists in England. Okay, now what is the case with India? In India as well, we have some very important but funny authorities. Okay, that you need to look at. Just a second. So before we go into the hopeless cases, okay, so there is one good case, okay, that we should start with, okay. So I'm not going to refer to any pre-constitutional cases, but there is one pre-constitutional case by the name P&O Steam Navigation Company, okay, P&O Steam Navigation Company case, okay. In that case, essentially the distinction was made between, without going into the facts, the distinction was made between sovereign function and non-sovereign function. Okay, although they did not tell us specifically what sovereign functions are and what non-sovereign functions are, let me give you some examples that will make you understand. So for example, law-making act of the sovereign function. Administration of justice is a sovereign function. Okay.
Excuse.
Yes.
So can you write down the case? The name
Yeah,
of the case?
I will write. Immediately. So I will just give you the abridged version. Okay, P&O Steam Navigation Company. P&O, okay, the P&O stands for Peninsular and Oriental Steam Navigation Company. So in this particular case, essentially what was held was that sovereign functions are different from non-sovereign functions, okay, ordinary functions, okay. So and then sovereign can, for example, employ someone to do certain work, okay. So, which would be just any other ordinary work that a private individual, you can also employ someone to do some work on your behalf, okay. The sovereign can also do that, okay. If in the course of such an action, certain, harm or damage is caused to someone, can that person then sue, okay. In this particular case, it was held that if it is of such a nature, then obviously the state can be sued, okay, the sovereign can be sued. But if it is the act is of sovereign nature, okay, if it is a sovereign act, then the sovereign cannot be sued. So I told you what sovereign act could be. So for example, enactment of a law, okay, legislative act, administration of justice, okay, law and order enforcement, or warfare, okay, those you understand probably, although we do not have a clear distinction here, but from the nature of the examples that I gave you, that they are of a different kind than, for example, running train or bus services and things like that. Okay, these two are different. Okay, so this distinction was drawn. It's a pre-constitutional case. Okay, after the
Excuse me, sir.
Yes, Aditya.
Sir, you said lawmaking also comes under sovereign act, right?
Yes, that's one of the most important sovereign acts. Yes.
So what if the government enacts a law and a section of the Indian population or the society suffers damage more than the rest of the people? What remedy will they have then?
Interesting. So if it violates your fundamental right, then you have the fundamental rights in the Constitution, and then there is this power of judicial review. So you have Article 32, you have Article 226, under which you can go to the High Court. Under 32, you can go to the Supreme Court if it affects your fundamental right. Okay, but as you know, there is always some harm that you suffer from any law which is enacted. Okay, but if it affects your fundamental right, okay, so it's case of public law, isn't it? So you can then, because it's constitutional matter I'm referring to, you can definitely then approach the court under 32, Supreme Court under 32, under 226 you can approach the High Court. Is that clear? Okay, so as you know, tort is a private wrong, isn't it? It's a private wrong, but that's like you're referring to something that is a public in nature, as I understand from what you were asking me. So I hope this is clear then. Okay. So yes, there is something called sovereign function. There is something called non-sovereign function. The distinction will still exist, but as you know, what used to be known as sovereign function earlier is gradually vanishing. Okay, the state is liable for almost every act. Okay, so you can let me show this to you under Article 300 of the Constitution. I'll just send you guys a link. So you guys have internet, so just click on this. Okay, so as you see here, Article 300 says suits and proceedings, okay, as against the governor, okay, the government, okay. The governor of India may sue or be sued, by the name of Union of India, and the government of a state may sue or be sued in the name of the state, okay, subject to any provision which may be made. Okay, so you can essentially sue the government as well. Okay, that's what essentially has been said here. So the Constitution also allows you to sue the government. Okay, so apart from that, the question is, what about this sovereign immunity in India? What is the position with respect to that? Okay, so with respect to that, we have some interesting cases, okay, that you guys should know of. The first important case, just a second. There are many cases, okay, so there are certain cases under the public law, but I'm not referring to the public law cases. If there are violations of your fundamental right, as has been held in many different cases, obviously you are given compensation. So, for example, the Bhim Singh's case, Bhim Singh versus State of Jammu Kashmir, then Rudul Shah's case, okay, or in all those cases, it has been held that, okay, if there is a violation of your fundamental right by the state, so it's a matter of public law, as Aditya had asked, okay. In such case, if there is a violation of your fundamental right, okay, then obviously the court can compel the state to pay compensation to you. But that's the case of public law. What about private law? Okay, under the private law, what happens then? So you have a very important case by the name State of Rajasthan versus Vidyavati. Okay, state, I'll type it here. Okay, you see this? Sorry, the last one is not V but W. Okay, it's State of Rajasthan versus Vidyavati, not Vati. Okay, so what happened? What had happened in this particular case was that a claim for damages was made by the dependents of a person, okay, who died in an accident caused by the negligence of a driver of a jeep, okay, maintained by the government for official use of the collector of Udaipur, while it was being brought back from the workshop after repair. So it was the collector's, jeep which was being brought back after certain repairs was done to it from the workshop, and while it was being brought back, it hit someone, that person died, and then its dependents initiated a suit. Okay, so the Rajasthan court took the view that the state was liable for the state is in no better position insofar as it supplies cars, keeps drivers for its civil services. So essentially what was held in this particular case was that state is not a special case so that it has some special immunity. It's just like you and I, okay? So it will be also be subjected to the same kind of liability. So one quote here is very essential for you guys, given by Justice Sinha. He said, the immunity of the crown, listen to the words clearly, okay? The immunity of the crown of the UK was based on the old feudalistic notions of justice, namely that the king was incapable of doing wrong, okay, and therefore of authorizing or instigating one, okay, and that he could not be sued in his own courts, okay. In India, ever since the time of the East India Company, the sovereign has been held liable to be sued in tort or in contract, and the common law immunity never operated in India. So this was the observation which was made. So essentially said that in India we do not subscribe to this old feudalistic idea that the king cannot be sued, okay, or tried, okay, cannot be taken to his own court, okay. That's not what that's not how we understand this in India. So in this particular case, okay, in the year 1961, it was held that that sovereign immunity almost does not exist according to this particular case. But then came a very sad case, okay, sad development that had happened subsequently, okay. The case is by the name Kasturilal versus State, okay. So we are past our time today, so I will leave it at that.